Hello, my name is Amarjot Singh, and I'm again here presenting a case which is of interest to me, and I'm sure a lot of people will also find beneficial. This is a federal court case, as you can see on the screen, and let me just show you some numbers here so that you can read this on your own. So this is the docket number, as you see here, and citation, and of course the date. So you can copy this in Google and then search this on your own and read this case in detail. So this case is by Ramanjit Singh TOKI and Minister of Immigration Refugees. This is quite not very old, 2017. And what I wanted to show you, actually I've already highlighted this so that you understand what is happening in the case. So this case is about the application for judicial review under Section 72(1) of FIRPA. And a visa officer in the High Commission of Canada in Colombo, they had refused Mr. Toki's application for PR under federal skilled worker class on 2016 November 3rd, and he was made inadmissible for misrepresentation under Section 40. As you know, it's a 5-year bar, so this is serious. That means we need to pay attention why it caused misrepresentation according to visa officer and some steps that we can take to avoid it. So this case was actually allowed judicial review. So the court overturned the decision by the misrep by the visa officer. So look at the facts here, some facts that you need to know. Mr. Toki is an Indian citizen, claimed to be working as a computer engineer in New Delhi. He applied for permanent residence under skill class in October 2014. What really happened was that the Canadian authorities conducted an on-site visit of what they believed to be his workplace. So when you apply for express entry or PR under different categories, you provide some employment information and they have to check it, they have to verify it. So one of the ways that they can check it is by doing an unannounced surprise visit to your location where you are listed as a work site, and then go and talk to people. This is sometimes leads to different results than what you expect, and this is what is happening here. So look at the highlighted here. Upon arrival, they found a woman who redirected the Canadian officials to a second location after having told them that the location on the letterhead was her residence. So it very likely the letter had the address of the residence of the company. And of course, what happened, the second location authorities met Mr. Toki's employer, the father. That means he was working for the father's company, who informed the official that the office has moved a year ago to another location. Officials believe that this alleged place of work to be fraudulent and prepared a visit report dating data. So they went to see the place. It was an residence. It was not an office place. And then he talked to the father, who was the owner of the company, possibly the employer. And the visa officers were not the investigation officer. I don't think the actual visa officer. The investigation officer must have concluded that this is a fraudulent job place, and the experience as documented on the application is not correct. So this is what sometimes many people are applying through work permit application, and then they list all kind of employment office address, and sometimes they are fraudulent, or sometimes they are not, and they do a site visit and they talk to a security guard and say, hey, do you know this person working there? And then they're going to say, hey, I don't know, and then the investigation officer will just move back and say, oh, sorry, we didn't find any, and the experience is fraudulent. So you got to be very careful what you are producing, what you are presenting, so that if there is any surprise visit, that people who are telling them, they should know that you are working here. I mean, of course, otherwise it is fraud. So that's why take a look at this case. Also, in addition, Mr. Toki submitted a case-specific inquiry to providing a new address. This is on April 27 after this has happened. And then, of course, they give you a PFL, which is Procedure and Fairness Letter, and then you have to apply to dispel those doubts that were created. So I'm going to just look at only the highlighted, which I had done to mention this. Mr. Toki stated that he was working in another office at a client site on the day of the visit. So on that day, Mr. Toki was not in that location. He was working in another location. So, of course, nobody could explain well, whether Mr. Toki was working there or not, or maybe they were not rightly qualified to provide them appropriate answer. Mr. Toki also provided an employment contract, 3 letters of support corroborating his version of events, including from his employer, remuneration documentation, invoices for work performed, copy of receipt for computer mouse purchase, and case-specific inquiry from April 2016, receipts for parking charges from the client side on that day, so he had complete evidence. Look at what the officer noted. The decision was negative. The officer stated that Mr. Toki deliberately misrepresented his employment experience. This made him inadmissible 5 years. The officer noted some inconsistencies and preferred evidence gathered on the day of the site visit as opposed to documentation. So the officer says, look, no matter what documentation you have, on the day of the site visit, I was not satisfied, and that's why I'm making you inadmissible. Wow. So Mr. Toki now challenges a decision by way of judicial review, and then so now we have the analysis of whether the procedure fairness was violated, number one, and whether it was reasonable enough for the visa officer to make him inadmissible. So I'm going to bypass the procedure fairness, because procedure fairness you already know. There's not much to discuss about procedure fairness in this case with you, but I'm going to jump to the reasonableness of the decision. And I'm just going down and down. Let me just go back to, I think it's, wanted to show you something that you will find it interesting. I'm going to, here it is. So assessment of evidence. So let's look at the first line. Even if my procedural fairness analysis is wrong, then for the following reasons, I agree with Mr. Toki's agreement that the officer's assessment of evidence was deficient. This issue, while assessed on reasonable standard as referenced previously, and thus while different in nature from the fairness analysis above, it is inextricably linked to the process followed, including information exchanges matter. Let me show you something else also. I don't want to waste your time in reading the background here of the case mentioned to the different case mentioned, Newfoundland and Labrador Nurses Union, comparing the facts from that case to this case. I have here. All right, take a look at here. What the number 34. What the officer does in test is to recount some of the evidence and note there are some discrepancies between the report and Mr. Toki's submission in response to PFL. The officer notes that there were no business offices where the Canadian officials undertook their site visit, and there were no computer labs that went next. I mean, the investigation officers found no business offices, it was a residence, and no computer lab. So, hey, this is unreasonable. But anyway, let's take a look at what happens next. However, what was not mentioned was the evidence, including the Florida office and the fact that Mr. Toki stated from the outset that he worked as a different location. So the visa officers conveniently ignored the fact that Mr. Toki said, hey, look, I worked at a different location, not at that location, and definitely not on that day. So how did you ignore this piece of information in making me inadmissible? So that's something to take a look. Look at number 36. In terms of lack of work experience claimed, reliance was simply placed on the statements of the business owner's father with no opportunity for Mr. Toki to respond. So, I get some information on cases where somebody actually went to a factory and then they talked to a security guard or a receptionist and say, hey, Mr. X is working here or not, and very likely chance that maybe the security guard or the receptionist was not even aware of whether Mr. X was working there or is working today, or maybe they have not even sometimes seen the face if it's a new employee. So based on response of somebody who is on the outside on the surface of the company's infrastructure, it is not fair for the investigation officials to actually make the determination that this person actually doesn't work here. So this is what this case shows. By just talking to the business owner's father, they made a determination that this experience was fake and this is not fair, and that's as you see on the 36. Let's take a look at number 37. Ultimately, the officer concludes where there are inconsistencies. I prefer the spontaneous information gathered during the verification of the information and document produced specifically in response to people and give them more weight. This is, as you can see clearly, is unfair. Based on a quick short and inconclusive, conversation with people on that day. They made the decision that Mr. Toki was not working there, so this is unfair. But of course, this case is very black and white, and as you can see why this case was turned down and he was made admissible anyway. But and let's take a look at the last line here on, I think it's on question 40. In some, even after considering the principles set out by the Secretary, I'm unable to consider how the officer came to the conclusion that the clear and comparing evidence existed. This case is very clear in showing that the visa officials and their team made an error in finding out that the Mr. Toki actually didn't work there. But other cases may not be as black and white, and that's why I always emphasize that you got to be very thorough and very complete in detailed in providing employment information, where you're working, for example, your appointment letter, your resignation letter if you've resigned the job, or the termination letter, or all the pay slips, all the references from the clients if you have external clients, your HR appraisal, if you have any appraisal things, anything happening in the company, you got to produce all the evidence so that there's absolutely no doubt that you did not work here. So this is what I wanted to show you in this case, and of course the conclusion is judicial review is granted. Let me show you the court case number again one more time. This is the docket number, citation number. You put these two on Google and type Federal Court of Canada, and you will be able to see this case, and then you can read the case in detail. All right, thank you very much for your time.